Hi, Alex Luizos here. And today we're going to talk about the strategy of the patents and the intellectual property protection in the world of artificial intelligence. Um, I purposely named that Do Cyborgs Dream of Electric Patents, the name of this module, because it seems that it's a very confusing theme, the patent or in the AI theme, because it looks like a lot like how can you patent intelligence? It looks a lot like the patenting of genome and individual genes debate. So there is a specific place. I spent lots of time and had lots of different opinions from several lawyers throughout my time in the AI world, but there is a specific place for patenting the artificial intelligence, and I believe that those that do it right and do it early will reap the most of the benefits. So, with that said, let's go and delve deeper into it. The first question we need to ask ourselves is: do I need a patent? Like, which stage are we? Like, have we even written a line of code? Have we even done anything? Or we just have like a platonic idea about a product, a device that will be using AI or intelligence at some point, and in order to procrastinate, we write down a patent. So the place that the patent is, it's not early on our company's development or concept development, unless we have developed a very, very sophisticated AI method, and we don't need to do anything else about it. We work in a university, we just need to patent it. But in the corporate world, the patent belongs to protecting your invention after you have created it. So if you are an early stage startup company, do not even worry about the patent if you haven't even started. If you are in the place that you have several clients, your system is working, and you believe that you're going to be able to scale relatively soon within the next few years, then at this point, you need to start thinking about patenting your system, because now it's a system. The secret about patenting AI is that we need to think about it as a system, as a device, virtual device that takes inputs, processes, does something innovative, and then gives you outputs. When we have this device, it's about time to patent it. Before we have anything, or we haven't even created anything, it's not the right time for a patent. One thing we need to remember, because people have gotten into trouble for that by patenting too early, is that the patent is a sword and not a shield. I will leave some time to think about it. The patent is something that can be used as an offensive mechanism and never be used to protect your company. Keep that in mind. So whenever we patent our invention, we attract lots of attention on our side. And in the patent world and the legal system of the intellectual property, the one with a deeper pocket always wins. So if you have a very, very nice device, which is working greatly, and you think that with the right pockets behind you, and believe me, if you have a great device, you will find deep pockets to protect you. You can actually use it offensively to monopolize a market, then this is a perfect place for a patent. But if you believe that you're going to create a patent to protect yourself from all the giants out there, welcome to the cockroach world. You're going to be stepped upon, and this is not the right application for your patent. So in a nutshell, do your patent when you are ready to go to offensive mode with people behind you with deep pockets. And this is a great place to be, because you are at exactly that point that you are ready to scale, and people with deep pockets are looking for great places that they can use their money to monopolize markets. So this is the perfect strategy for an AI patent. In order to protect your company while you do the patent, you need to do lots of prior art research. So you make sure that you don't step upon any giants, IP 500 lawyers department. So be careful to do lots of prior art research and do not conflict with any of the claims of your competitors or client names. Use lots of synonyms, use lots of thesaurus. There is a specific module after that to analyze this process. Try to obfuscate. The whole secret is to be stealthy. It's not like a paparazzi kind of announcement with all the photographers around us and the press release that we've got a patent. No, this is a stealthy Assassin's Creed kind of situation that you need to keep it under the hood till it's time to go into offense mode. So we use an obfuscated title for our invention. We never use buzzwords. We never use the words that somebody would make it easy for somebody to find us. Another strategy that I've seen lots of people doing, especially on early stages, is that they create an IP holding company, which is owned by your current company. Of course, you got to ask your board, because having a separate intellectual property holding company can create some power issues or some control issues. So we always need to be aligned with our stakeholders. So always ask your board before you do it. Although it's a great strategy, because at any point that anybody tries to attack you, will not attack your company. They will have to breach the corporate veil to get to your company. And they can only attack the IP holding company, which is a shell company. So what's the best strategy for us to avoid all these issues and to do it fast and to do it at the point exactly that we need a couple of years to scale and to actually reap the benefits without getting into troubles and going through the difficult road? So we will start with a provisional utility patent only. Yes, provisional utility patent, because it gives us 1 year priority while nothing is revealed. No claim, no text, no diagrams, nothing is revealed from our point. We can drop it at any point, even at the last day of our provisional patent expiration date. There is no need for any holding IP company, because there is no actual real IP yet. It's just like an application. You can actually send like a sketch on a napkin on the USPTO to the patent office. It's very, very cheap. It's like a few $100s. So you can do it like fast and cheap. You can always work on it as long as you want throughout the year, keep on adding stuff while you're keeping your priority time on the date that you applied for the patent. And I think this is the most efficient, stealthy, less dangerous, all the options on your side strategy for a patent. So, final checklist. Before we start doing the patent, what do we need to think as executives? All technical authors have transfer IP agreements, and they are paid for their work in the patent. Nobody does any volunteering, or nobody works on the patent without getting paid, or not having any transfer IP agreements. So we double check for every author that there is a transfer IP and they are getting paid for their work. And they're using the devices of our company, or through the transfer IP, this is covered. All the authors are included. This is very, very important, because some people get this part egotistically, that only the executive names should be on the patent, and this is actually we shouldn't have our employees on the patent names, etc. Doesn't even matter. The more technical authors, the more employees we have in our patent, the better the merit for the IP for the patent office, the better for our company. The company belongs, the patent belongs to the company. Doesn't matter if we have like 20 names and my name as an executive is not there. The whole point is to get the patent out there, regardless of the names. Let the employees have fun with it. Let them enjoy the participation on that, and the patent belongs to the company. The prior art needs to be done deeply, and we try to avoid doing something that there is something completely the same there and we didn't even see it. And moreover, in a year from now, we will attract unwanted attention because one of the giants saw that we stepped on their toes and we did an ant's bite, and they are now annoyed. They're going to come after us. So we want to avoid this kind of mistakes. These are rookie mistakes. So we do we spent a couple of days doing the prior art. And we are ready to apply at the point that we will be scaling in a couple of years down the road. So we can start like with provisional pattern now. In a year down the road, we are ready and we have our pockets plus support from our stakeholders and other people that want to put oil on fire with their money to support us for the cost for the domestic pattern. We start with domestic, and then we're ready to go to international pattern. So we have the cost considerations in our mind, and we're ready to support it within the next year or two. And now, how can we keep our team, our authors and our technical team from jerking around and not doing anything? This is a very, very important stuff. It should take less than 2 weeks to complete the provisional pattern effort. And there is a brilliant way to operationalize it, which I will let it for the technical team. You can always, of course, watch it if you like. Congratulations, you're in a great place, and let's do this. Thank you so much.